Thank you very much, Mr. Ayaz. Now, Advocate Ashwini Dubey is also with us on the broadcast. Appreciate you joining me live on the broadcast. Mr. Dubey, when we're talking about, in fact, the numbers in the parliament and how the debate has been set and scheduled for the 8-hour-long time where the recommendations, the opposition will also be looked into much detail. How exactly do you think that all these numbers by the NDA, which the NDA as of now remains very confident that the bill will be passed and this is going to be a success move by the NDA. But when we talk about the numbers, what exactly do you think can be expected as by 12 p.m. we look forward to the bill which will be presented?
Ultimately, litmus test is to be done in the parliament, and the ruling party which is introducing this bill, if were not having the sufficient numbers, would not have come to this, bringing this legislation. See, the numbers has to be decided inside the parliament. It's a matter of house. I would like to add further what Ahmed Sabha has said. Why this was needed? Because the numbers is the politicians has to decide. I'm not a political person. I'm not a political analyst. My brother Sumit Peer is a political analyst, so he would enlighten us about the numbers and the political support which the NDA is having. The country is a dharma nirpeksh country. If country is dharma nirpeksh, then why laws are for the dharma vishesh? Point one. Point two, there are country establishes the constitution rather itself, because time and again the constitution and constitutional provisions are cited in order to say that this constitution is violated. Samvidhan ki hatya ho rahi hai. The constitution does not discriminate in the name of the religion. It says that everyone who is in the country will be having the equal rights. Then there are three types of court in the country which the constitution establishes. One is the union judiciary, which we call the Supreme Court under Article 124 to 146. Another is the High Court under Article 214 to 231. Third is the subordinate court under Article 233 to 237. And correct me if I'm wrong, and I would like to stand corrected, that if any property dispute is there, that has to be go and decided by the court of law. But here, if someone from the Waqf board puts a finger towards a property and has a reason to believe, I'm again using the word with all responsibility, if a board or board members or mutawalli has a reason to believe that Sumit Peer's property belongs to the Waqf, donated at one point of time in past, then there is no mechanism and redressal available to Mr. Sumit Peer to go to the court of law established under the constitution which I just mentioned. All three courts. Where this property dispute would go, that dispute would go to the board. And then if you go to the board has a Muslim MLA, Muslim MP, Muslim IS, Muslim town planner, Muslim advocate, Muslim scholar, Muslim mutawalli. If both decided that this Mr. Sumit Peer's property is of the Waqf property, then the only remedy is the tribunal, and that again the tribunal composition is with the same set of people. And there is no appeal or revision against the order of the tribunal. You can't go to the High Court or the Supreme Court. Okay. Means that the constitutional framework which establishes three kinds of court is not applicable, and Supreme Court and High Court does not have power, because the law does not, Parliament does not give them power to decide a property for which a person belonging to a particular community has a reason to believe that this is his property, and therefore the court will not decide. Because the courts are powerless, law has to be framed by the Parliament. Don't you think that law needs to be amended? Point number one. Let us come to the point number two. Section 40 is a draconian section under the Waqf Act. Means that as per Section 40, if any property came into the Waqf board and Waqf would decide that this property is in the and in 2030 amendment which was brought, which says the person aggrieved only, means that if Waqf board wants to observe the government property or a park, and any individual does not have a right because he is not the person aggrieved, that automatically will fall in the Waqf board. Point number 3, it is not only the Hindus, Bauds, Jain, Christians, Sikhs, Parsi, Judaism. It is also the Muslim community which is largely affected by the act which is established as of now. Now, number 4th point, you see the 1954 Act passed provided a pathway towards the centralization of the Waqf. Central Waqf Council of India, a statutory body. Parliament says every law passed by the Parliament. Why the Waqf board is above the Parliament or above the constitutional provisions? Now, if the Parliament takes a decision that look, you have a right to appeal to the High Court, what is wrong in it? Where it is against the constitutional, religious right of any individual of any particular community, that nobody should be allowed to go to the High Court. Point number 3, if a judge belonging to the another community says that because judges are impartial, independent, and we believe in a system where judges are not less than God, they decide the case based on the property, the evidences available. And if judge is not that particular community, then you are not understanding that if he is not from your community, and if he is from some other community, like he is Dubey or he is Pandey or he is of any other community, then you don't have a trust over the judge. Now, 4th is that if government property like the Kartavya Path, like the Rajpath which used to be earlier, Delhi High Court, or a 1500, 1600 years old villages, if a board decides that this falls in the Waqf board, and therefore the temple and other properties has to go, villagers have to leave this property because ultimately it has fallen in the Waqf board. Don't you think that the people who are residing there have a right to challenge that? So that is the basic question. And that is why you see, it's not my statement, your statement, Sumit Pir's statement, Ayaz Saab's statement. It is a statement largely circulated to the media that the Waqf is the largest property land holder. यानी जमींदारी प्रथा हमारे देश में खत्म हो गई और जमींदारी के वेश में ये वक्फ बोर्ड आ गया. वो don't you think that has to be abolished or that has to go? In fact, as a student of law, I would say it would have been abolished. And people should have given right to approach to the court of law. And one of the clause E which says that retrospective applicability does not have, this should have a retrospective applicability because Places of Worship Act has also the retrospective applicability. So it cannot be said that law should have a prospective effect. But that is whatever we are getting, your country is getting. And if you have a trust in the legal system, then you must not oppose
right.
it.
Mr. Dubey, I would like to take a minute to also address this issue that the bill amends the Waqf Act of 1995. A lot of detail that has already been put in focus by you, and it also governs the management of the Waqf properties in India. But the opposition's primarily contest is that it proposes sweeping changes in giving the government a foot in the door in regulating the Waqf properties and settling the disputes regarding such properties. But the question is that the judicial oversight of Waqf management is also a key issue of the opposition. There are questions which are concerning Waqf properties are heard by the Waqf Tribunal, and decisions of whose which cannot be challenged in the court. So how do you in fact would want to comment, because I've been hearing about the justifications that you've been given. So how do you like to comment on this part where the opposition has also been raising the concerns?
This is not my justification, with due respect. This is the justification of crores and crore people who are affected by this draconian act. This is a justification where one person whose property has been fallen under the Waqf Act and wants to challenge it before the court of law, and when the High Court and the Supreme Court says that look, the tribunal has taken a final decision and therefore we don't have a right, and you too don't have cease to have any right to come to the appeal either under Article 226, 227, Article 32 of the Constitution of India. So two courts. Supposingly, if you are aggrieved by any decision of any other tribunal, like the National Company Law Tribunal I'm talking about, National Green Tribunal I'm talking about the Seagate Tribunal, I'm talking about the Consumer Protection Act, any other tribunal, if you are affected by your right to go to the High Court and the Supreme Court. This is the only unified, exceptional, classic tribunal in the country. Against the order cannot be challenged in the court of law. So don't you think that the right to judicial remedy is a fundamental right and nobody can take it over? That's the question. And it is not that I am in favor. I am not a BJP man. I am not an RSS man. I am just an individual.
That's a fair question to actually raise at this point of time. Nobody is actually projecting if someone is in favor or against. The questions that are being raised